If you were ever to become mentally or physically incapacitated, or when you die, there are things that have to be taken care of. Either you have to deal with your physical care, you have to deal with financial matters, you have to deal with perhaps a whole estate.
If you pass away without a will, then that process is called intestate probate. And what that means is that each state law, the state law where somebody resides or where they own real estate, will govern the disposition of their estate.
If you don't have an estate plan in place, it's then up to your family, the courts, and the state statutes to determine where your assets go. If you want to have any control over who manages your estate, where your assets go, and if things are going to be done according to your wishes, it's best to have these things in place as soon as possible.
One of the important considerations you have when coming up with an estate plan is not only to preserve your material assets, but also to make sure that those you leave behind are provided for. For instance, if you have an incapacitated sibling or spouse or child, it's important to nominate those guardians and conservators to take care of them when you pass away. In cases of minors who are left behind or individuals who are incapacitated, it's a way that which we can communicate the directions for their ongoing care once we have left this world. If you die without a plan for a guardian and conservator, somebody would have to apply to the court to be appointed guardian conservator. In many cases, this may be an amicable resolution, but there are some instances where families may end up fighting over the care of the children.
The probate process can be arduous. You want to make sure to have these things laid out ahead of time as much as possible to make it easy on your family. The more instructions you have laid out for your family and your loved ones, the easier it makes this process for them.